Very often, owners do not understand the differences between the role and functions of Resident Association RA as compared to Joint Management Body JMB and Management Corporation MC and the legislation from which these community bodies are formed. Now, let us examine some of the differences between RA scheme contracted and bound by the deed of covenant, rules and regulation, when the purchaser signs sale and purchase agreement, and those management bodies mandatorily established under the SMA. Now, in this episode, I would like to enlighten you on the roles and responsibility of these community bodies titled Knowing the Differences Between JMB, MC and RA. Much has been talked about Joint Management Body JMB and Management Corporation MC, and we now have at least a basic understanding of the functions, powers, and working mechanism of JMB and MCs, which are established under the Strata Management Act 2013 SMA. Now, there's yet another type of management body commonly known as Resident Association RA in non-stratified development, which is usually registered under the Society Act 1966 to serve some of the functions undertaken by JMB and MC in stratified development. Over the years, developers have been promoting the concept of exclusive resort-style living by offering landed properties with amenities within the gated and guarded areas surrounded by perimeter fencing. While this can be achieved by having landed and horizontal strata development, thus attracting the application of SMA and its bylaw enacted thereunder, there are some housing projects that are not developed under the strata regime but are built according to a conventional scheme wherein individual titles under the National Land Code are issued to each purchaser respectively. In the later case, usually an RA is formed by developer or purchaser sometime after vacant possession delivered to take over the management and control of the development area. This usually happens to newer development. Now, on the other hand, for existing development, RA is usually established to improve safety in a residential development area. The establishment of an RA is a prerequisite for setting up a gated guarded community under the guidelines of certain local authorities. For purpose of this article, we shall refer Resident Association both in respect of newer and existing development as RA schemes. Let us examine some of the differences between RA scheme and a management body established under the SMA, i.e. JMB and MC. Voluntary or compulsory? Now, in new development, where RA scheme has been planned in advance by developer, even before the commencement of construction, purchasers are bound by the deed of covenant called the DMC, which is usually signed together with a sale and purchase agreement. Therefore, it is unlikely for a purchaser owner to opt out from an RA scheme. Situation is slightly different for existing development which choose to adopt RA scheme subsequently. Now, in this scenario, a purchaser owner can choose whether to participate in an RA scheme or otherwise. The higher the participation rate is, more money can be collected and spent to improve the security system, perimeter fencing, guardhouse, patrolling, and well-being of the neighborhood area. Most are initiated for the sake of security purposes on a self-help basis and to deter crime. While there is no uniform law governing the RA scheme, certain local authorities have issued guidelines which state that a gated and guarded community can only be formed by a registered RA, which represents certain minimum threshold number of occupants, owners in that development area. For purchases of stratified development, the SMA and its regulation will apply automatically regardless whether a DMC is signed with the developer. Governing rules. All benefits enjoyed by purchaser owner under the RA scheme are of course not free of charge. In new development where RA scheme is practiced, purchaser owner are mandated by the DMC to contribute maintenance charges on a monthly basis. In other words, unlike the strata scheme, which derive its authority from the federal law, the purchaser's obligation in RA schemes are contractual in nature. In order to enhance the enforceability of the DMC usually contains a clause which states that the DMC shall bind the developer and the purchaser owner and at the same time binding upon purchaser inter se. Nevertheless, the effect and the limitation of a purchaser suing another purchaser based on a breach in the DMC have not been fully tested yet in Malaysian courts. In addition, the DMC usually contains clauses which state that an RA shall be formed within a period of time after vacant possession to take over the management of the amenities provided by the developer. One of the advantages of the Strata Management Act SMA is that it contains a host of comprehensive rules which regulates different aspects of communal living, etc., the election of community members, the proceedings of a AGM, the requirement to audit accounts, the preparations of meeting minutes, the recovery of sinking fund and maintenance charges, etc. However, all these are not readily available to RA scheme. In this regard, the rules governing the interaction between the purchaser are expected to be documented in the DMC. There is already a reported case where the developer sued a purchaser and successfully recovered maintenance charges relying on the terms in the DMC. However, complication arises when a first purchaser of a property sells his property to a subsequent purchaser. In that case, the subsequent buyer is arguably not bound by the DMC because he has not signed the DMC. It follows that he can choose whether or not to pay maintenance charges. In order to circumvent this hardship, it is common for a DMC to contain a clause which states that the obligation in the DMC shall continue to bind the successor in title and assign, etc., of the first purchaser who have signed the DMC. Now, some DMC even impose a positive duty on the first purchaser to ensure that the immediate subsequent owner of his property will sign an identical DMC with the developer. Be that it may, the issue of ensuring continuity of obligation in an RA scheme remains a challenging one. Now, in the case of existing development, RA is usually formed after the residents have voluntarily grouped together and achieved a certain threshold number of owners. Upon the formation of RA, members are additionally bound by the constitution of the RA, which is filed with the Registry of Societies. The rules and practices are governed within the four corners of the RA constitution. Dispute resolution. Now, the SMA established Strata Management Tribunal, which is tasked to hear and decide on strata-related dispute in an efficient and economical manner. The jurisdiction of the Strata Management Tribunal is wide-ranging and includes hearing claims on recovery of charges, deciding on the validity of resolution passed in a general meeting, nullifying amendments of bylaws, making order to compel production of documents, etc. I've in fact published an article titled Strata Management Tribunal, Scope, Jurisdiction and Power. Please surf the internet for the link. On the other hand, in the event that there are any dispute between the purchaser-owner in an RA scheme, the last resort is for parties to file a civil suit in the court of law to resolve the dispute. There is no specialized court or tribunal which are set up to hear disputes arising from RA schemes. Conclusion: a RA scheme in new developments comes into existence based on the terms in the DMC, which is initiated by the developer. It is hardly surprising that in many instances, the clauses in DMC are worded in favor of the developer. It is thus imperative to go through the DMC to fully understand the more important provisions, such as the manner in which maintenance charges could be increased, how the collected sums are accounted to the paying owners, the transparency in the working of the RA, the duration upon which the developer will initiate the formation of the RA scheme, and the passing over to the purchaser owner themselves to manage, etc. It's only by doing this the purchaser's interest will not be eroded. Food for thoughts. Now, with the mushrooming of these gated communities and guarded neighborhoods, we urge that a federal law be initiated to regulate and control such a G&G instead of relying on Garis Panduan guidelines. Those cross-referred laws like the Street Drainage and Building Act 1974, Road Transport Act 1987, National Land Code 1965, Town and Country Planning 1976 too have to be amended accordingly. My next talk will be titled The Follies and Foibles in Community Living, where I will share with you the lighter side of HBA and yours truly on what I call the follies and foibles in any housing community. It contains the bare humor and posts our lighter side of HBA's passionate effort to strive for the interest and betterment of other house buyers. It is our lighter side that keeps us sturdy and potent with the current state of affairs in the arena of housing ills. Hence the catch-all adage. Our free service for nice people only. See you in the next episode. Cheers.